Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Fatin Farahusna binti Maliki, matric number 1710252, and today I will presenting about the introduction of Sharia Court. First, Sharia or Sharia refers to Sharia law in Islamic religious law and deals exclusively with Islamic laws, having jurisdictions over all Muslims in Malaysia, and the Sharia court system is one of the two independent tribunal systems that operate in the Malaysian legal system. There is a parallel state system, which is Sharia court, which has limited jurisdictions over state Islamic law about Sharia matters. The Sharia courts have jurisdictions over Muslim only in matters of family laws and religious observance, and can usually only impose sentences of up to 3 years and fine up to 5,000 or both. Article 145 of the Constitution specifies that the Malaysian Attorney General has no authority over Sharia-related matters. Unlike Malaysia's civil courts, which is a federalised court system, the Sharia court is constituted solely by state law. Likewise, Sharia or Islamic law is a matter of state law, except for the Malaysian Federal Territories, as provided in Article 3 of the Constitution. Thus, the law of Sharia is one state may vary from another. For the Federal Territories, there are 13 departments of state Sharia law and 1 department of Sharia law. Next, the foundation of Sharia Judicial Department in Malaysia. They have 4 foundations. The first is to create administration related to Islamic law and setting a standard practice for Sharia court, which all states will adopt. Second, to ensure that states use the Sharia Officer Gunasama Service Scheme. Third, to ensure the cases are handled fairly, efficiently, and organized by the Court of Appeal. And last but not least is to maximize broadly the use of IT systems to promote smooth administration. Next, we move to the functions of Sharia Judicial Department. They have 10 functions, which I will talk only 5. The first one is formulate policies and strategies in all states to improve the court's standardized organizational performance. Second, coordinating the Islamic legal system and the Islamic judicial procedures for all states to adopt. Third, guiding and evaluating state Sharia court programs and activities which embrace the Sharia Officers Gunasama Service Scheme. Fourth, administer and organize the rules, ethics, and guidelines for action, as well as procedure for all Sharia officers and personnel of the Sharia Court of State. Fifth, managing the requirement and development of skilled human resources that meet system demand. That's all from me.
Bismillahirrahmanirrahim. I'm Aisyah Munirah binti Syahri. I will present to you about chapter 2, the historical background of Sharia courts in Malaysia. Evidence shows that during the reigns of Melaka, Malay sultans and Malay kings, and before the arrival of Western juristic influence, there was a form of regulations called Old Malay laws, which is Undang-Undang Melayu Lama, and it can be said that every state had their respective law text. Okay, the first one is Melaka Malay Sultanate. In general, the regulations in this text show clearly two forms of system, that is custom and Islam. Therefore, the laws for the Malay society and rulers at that time were Malay customs and Sharia. The provisions for punishment in the Risalah Hukum had a strong Islamic influence in the criminal field. This proves the acceptance by the rulers of that time of Islamic law. And Islamic law influence was more clearly seen in marriage, divorce, and estate distribution. In fact, the Muslims in this country from then up to now have been marrying according to the Sharia. So this is the in general and Malacca Malay Sultanate. Next, move on to the reign of the Malay kings. After the fall of the Malacca Malay Sultanate, other Malay governments were formed, such as in Pahang, Johor, Kedah, Kelantan, and Terengganu. The position of Islamic law in the legislative system of those states were increasingly clear. In 1830s or much earlier in Kota Baru, there were established posts such as Mufti and Hakim. Yeah, the job of Mufti involved the running of the judicial powers with the existence of the Qadis in the Qadis court. In general, the criminal cases were decided and punished according to Islamic law. Death sentence entailed compensation, and punishment for theft was the cutting of hand. Sultan Zainal Abidin III continued with the same method. In fact, His Highness himself had made it easy for those who wanted to follow Islamic law. During his reign, all forms of gambling and court filing were made illegal. Yeah. And for the last stages, which is the English colonial era stage, the Straits settlements. During the early stage of the enforcement of English law in the Strait settlements, the position of courts jurisdiction in enforcing the Islamic family law was not clear. Also, for the first time during this stage, it gave recognition to the Qadis post and gave it limited jurisdiction. However, there were provisions for Islamic law and textbooks for it. Okay. Next, for the Federated Malay States. The Federated Malay States, Perak, Pahang, Selangor, and Negeri Sembilan had received English advisors. Under this system, the sultans were asked to accept British residents in which their advice will be used and acted in all administrative and financial matters except religion and the Malay customs. And with the unification of the 4 states that I said before, the English revised all laws in the states, including Islamic law. Every state had laws for the administration of Islamic law. With the above provisions, it enabled the courts to enforce Islamic law to the extent provided for by the power. And the last one is for the unfederated Malay states, which is Perlis, Kedah, Kelantan, Terengganu, and Johor. And here, the background and position of Islamic law in the states were the same as in federated Malay states. All law provisions made for the respective states were quite similar. It limited the jurisdiction of the Qadis courts. In the colonial era and after independence, matters concerning enforcement of Islamic law are in the hands of each state government, where the Sultan is the head of religion. So today, any amendments to the Sharia courts jurisdictions are under the jurisdiction of the state assemblies, which are bound to the Malaysian Constitution and the relevant acts of Parliament. Although the jurisdiction of the Sharia courts in the whole country is not uniform, there are many similarities between the states.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Asha Subtika Sulaiman, and I will be sharing about history of Sharia court in Malaysia. The administration of Sharia courts in Malaysia was from the pre-colonial to the post-independence period. the status of Islam as the official religion during the monarchical sultanate and the application of Islamic law throughout the administration during that period are agreed upon by most historians. The structure of courts consisting of subordinate and superior levels with the Sultan as the head of the judiciary shows the existence of an organized structure which recognized natural justice as one of the rules of law. In the 15th century, Islam was established in Malacca. Islamic law came into force when the nobles and kings embraced Islam, and Islamic laws already existed at that time. The fall of Malacca in year 1511, the Portuguese and later the Dutch had colonized Malacca. However, the position and implementation of Islamic law was not affected. Beginning 1786, the arrival of the British took Penang and Kedah as the starting point of the effort to set aside Islamic law. They consider Penang when it does not have any legal system and claim that Islamic law practice was wrong. In 1948, the Sharia court was placed separately from the Federated Malay States and was at the bottom after the Penghulu Court and the Magistrate Courts. It was known as Qadi Court. The subordinate position given to the Sharia court in the early days before and after independence has to a certain extent empowered civil courts to override their decision. However, the passage of time, the Sharia court has been structured and positioned in a more remarkable place. After Merdeka, the restructuring and restoring of Sharia courts in Malaysia took more than 40 years. Subsequently, the current Sharia Court Acts and state enactments have been amended and improved to bring them into line with the policy of government, current situations, and legal pluralism in Malaysia. Sharia Court in Malaysia was established in all the states through administration of Islamic law enactments in the federal territories through the federal law, except for the territories of Kuala Lumpur, Labuan and Putrajaya, whereby the constitution, organisation and procedure are state matters. Sharia courts in the Federal Territory of Kuala Lumpur was established by the Yang di-Pertuan Agong under Section 40 of the Administration of Islamic Law, on the advice of the ministers charged with the responsibility for the administration of Islamic law. Now, three-tiered systems that are currently used in the Federal Territory of Kuala Lumpur are Sharia Subordinate Court, Sharia High Court, and Sharia Court of Appeal. That's all for me.
Okay, my name is Nunaila Wahida binti Wahab. Okay, today I want to present about position and jurisdiction of Sharia Court in Malaysia. The first topic, position of Sharia Court. Let's start with the first point. As we know, the Sharia demands the establishment of the Islamic judicial institution without which the Sharia law can never be implemented and practiced. Justice and fair play, which has always been held and assessed by the Sharia, can never be upheld. Nowadays, Sharia court in Malaysia has transformed into a strong institution in Malaysia with a number of substantive law, procedural law, and other subsidiary law since independence. The establishment of the Department of Sharia Judiciary (JKSF) is indeed an achievement in the Islamic legal system. Unlike the High Court, which is established by the Federal Constitution, the Sharia Court is a creature of a state law. Article 74 of the Federal Constitution, read together with the state list, prescribe that Islamic law and Islamic matter, including the establishment of Sharia Court, fall under the jurisdiction of the state. According to the state list, the legislative power of the State Assembly to legislate on Islamic law and Malay custom is confined to 26 of matters: succession, testate and intestate, betrothal, marriage, divorce, dower, maintenance, adoption, legitimacy, and so on. The second is wakaf and the definition and regulation of charitable and religious trust, the appointment of trustee, and the incorporation of person in respect of Islamic religious, and so on. The third is Malay custom. The fourth, zakat, fitrah, and baitul mal or similar Islamic religious revenue. Then mosque or any Islamic public place of worship. Then creation and punishment of offences by persons professing the religion of Islam against percept of that religion. And the last one is constitution, organization and procedure of a Sharia court. Any problem that arise pertaining to the Sharia matter, and the party will have to go to Sharia court to determine their claim, even to Sharia law provided regulation in all aspects. The Sharia law that is applicable in Malaysia is confined to only personal matters, amongst other, for example, the law on marriage and divorce and the distribution of estate before the after death. Okay, that's all for me. So let's continue to my friends.
My name is Rajini Balkish binti Abu Bakar. Inshallah, I will continue to jurisdiction of Sharia court in Malaysia. In Malaysia, the Sharia court is classified into three categories that are the most important to all Malaysia. The first court is Sharia Subordinate Court, also known as Lower Court for Sharia Matter. Second, Sharia High Court, and last is the Sharia Appeal Court. About the Sharia Subordinate Court that has only original jurisdiction. In civil matter, jurisdiction cover all such proceedings as the Sharia court is authorized to hear, but limited to the proceeding in which the amount or value of the subject matter in dispute does not exceed to 50,000 ringgit, or the monetary value cannot be estimated. It means that the Sharia court is empowered to hear, but there is limited in value of money. In criminal matter, the jurisdiction of offences under the Sharia Criminal Offence Federal, which means Federal Territories Act 1997, or any other written law prescribing offences against precepts of the religion of Islam. The maximum punishment for such an offence should not exceed 2,000 or imprisonment for a term of 1 year, or in both. The second is Sharia High Court, which has the three jurisdictions, which are original, appellate, and supervisory and revisionary jurisdiction. First, for the appellate jurisdiction, appeal will against the decision of the Sharia subordinate court in civil and criminal matter. It will against in the two matters for this one. Why? For the civil matter, where the amount is not less than 1,000, concerned to the status or maintenance of defendant. But it cannot hearing of appeal against decision that made by consent. In the criminal matter, hearing of appeal against the acquittal, conviction or sentence, power to dismiss appeal, convictions or sentence, order the trial court to make further inquiry, reverse any order of the trial court, or order a retrial. While for the supervisory and revisionary jurisdiction, which is the Sharia court, may it at its own motion or at instance of any interested party in any stage of any proceedings in any Sharia court, call for and examine any record and give such directives as justice may require. It means Sharia court may it want what they want choose and can choose any party that interested in each state of proceeding. Sharia Court Appeal. Sharia Court Appeal has two jurisdictions, which are appellate and supervisory and revisionary jurisdiction. For the appellate jurisdiction is hearing of appeal from the Sharia High Court. It may also determine question of law of public interest arising in the course of appeal in the High Court from the subordinate court. For the last one, supervisory and revisionary jurisdiction is the Sharia Appeal Court may call for examination at any stage of proceeding in the civil matter and criminal. In the Sharia Court, the record of such proceeding and give such direction as justice may require. For the conclusion, the jurisdiction of the Sharia court is divided into both, which is criminal and civil. It have different producer apply in both jurisdiction. Only a Muslim, either by birth or birthway or of conversion, can go to the Sharia court. In other hand, the Sharia court can hear cases where a non-Muslim is also a party to the proceeding. The federal constitution does not clearly state that the non-Muslim cannot be called a witness. That's all from us. Thank you.